statutory interpretation under the Human Rights Act. How are we going to understand the dynamics of judicial practice in this area? Let's begin with the Human Rights Act itself. The interpretive provisions of the Human Rights Act have had a major impact on judicial interpretive practices. Our consideration of the new practices has to begin, as I've suggested, by looking at the Act, at Section 3 of the Human Rights Act. The range of this provision is worth noting. It applies to primary and secondary legislation whenever enacted, before or after the Human Rights Act. The effect of Section 3.2b, however, is that the incompatibility of a piece of primary legislation with the Human Rights Act does not mean that the legislation is to be held void. The duty of the court is to interpret legislation as far as possible as consistent with the Convention. However, if it's not consistent with the Convention, the courts do not have the power to hold that that piece of legislation is void. In other words, as I've pointed out before, parliamentary sovereignty is left in place. The pressing question is, how will the courts interpret legislation in the light of Section 3? The Government White Paper, Rights Brought Home, a document we've already looked at, stated that Section 3 would go far beyond the rules prior to the Human Rights Act, which had allowed the courts to take into account the rulings of the European Court of Human Rights in interpreting legislation and clarifying ambiguity. The White Paper stated that the courts will be required to interpret legislation so as to uphold Convention rights unless the legislation itself is so clearly incompatible with the Convention that it is impossible to do so. This White Paper then clearly articulates a rule of interpretation. It does, however, leave a great deal of discretion in the hands of the interpreter, in the hands of the judge, to determine whether or not it is impossible to interpret legislation as compatible with the Convention, or indeed as possible to interpret as compatible with the Convention. Once again, we're concerned with what I think is the pressing question in this whole area of law, and that is where the constitutional boundaries of judicial practice lie. The only way of really resolving this question would be to look in detail at a great number of cases. We can't do this, so once again, what I'm going to try and do is use a single case. The case is called Gaydon and Godin-Mendoza, to try and illustrate some of these broader themes. The case saw the House of Lords dealing with a question of property law that related to a succession of a tenancy under paragraph 2 of Schedule 1 to the Rent Act of 1977. The defendant in this case was contending that the Rent Act discriminated against him as a homosexual in depriving him of rights over the flat of his deceased partner, the apartment of his deceased partner. What precisely was the issue in Gaydon? Paragraph 2.2 makes a distinction between a heterosexual and a homosexual couple who are living together. For the former, the survivor can take over the tenancy if the property was in the name of the deceased, whereas for the latter, the survivor cannot. The survivor in a gay relationship is not deprived of all rights over the property. He or she is entitled to an assured tenancy. However, in terms of both rent protection and rights against eviction, the survivor of the homosexual relationship is clearly not in as beneficial a situation as the survivor of the heterosexual relationship. The Court of Appeal, when it heard this case, had held that the Act in question, the UK Act, the Rent Act of 77, amounted to an infringement of the defendant's rights under Article 8 and 14 of the Convention. The Court of Appeal had used Section 3 of the Human Rights Act to read the Act in a broad way, thus allowing the defendant to take over the tenancy of the flat. The House of Lords dismissed the appeal against this ruling and confirmed the approach of the Court of Appeal. What the court therefore didn't have to do was issue a declaration of incompatibility, as the Act could be read in such a way as to make the UK Act Convention compliant. The House of Lords did note, however, that the new meaning of the Act, the new way that we read it, the new way that it is read by the judges, must be consistent with the fundamental features of the legislative scheme. And I want to investigate this argument in a little more detail. In Gaydon in the House of Lords, Lord Nichols pointed out that there are a number of ways of reading Section 3, because there's an ambiguity in the Human Rights Act itself, an ambiguity in the word possible, to construe UK legislation in such a way as to make it possible. A narrow reading would hold that Section 3 only allowed the courts to resolve ambiguities in statutory language in favour of convention-compliant interpretations. A much broader interpretation of the section has been preferred. This allows the courts to give a different meaning to the language of the statute in order to make its meaning consistent with the convention. This could involve reading words in, as in an earlier case called the R&A, Crown and A. There is no need for the language of the Act to be ambiguous for the court to take this course of action. This means that the court can depart from the unambiguous meaning the legislation would otherwise bear. Normally, the court would have to determine the intention of Parliament by using the language in the Act. However, Section 3 means that the court may have to depart from the intention of the enacting Parliament. So, we can begin to appreciate how the Human Rights Act makes for a potentially radical departure from conventional methods of interpretation. However, this does not extend to the idea that the court is now an equal partner with Parliament when it comes to legislation. The fundamental requirement is that the courts should follow parliamentary intention in interpreting the Act. The question becomes, how would a court know that it is legitimate to depart from parliamentary intention? The answer to this question depends on the degree to which Parliament intended that the actual words of the statute, as opposed to the concept that those words express, is to be determinative of the Act's meaning. What does this mean? Lord Nichols argues that the determinative factor cannot be the word or the words of the Act, since the Human Rights Act allows them to be interpreted against their obvious sense. It would be possible, therefore, for the court to read words into an Act. This would be consistent with the fact that Section 3 requires that the court read in words to make an Act compliant with the Convention. There is, however, a limit to this process. Although the court can read words into an Act, Parliament could never have intended that the courts should adopt a meaning inconsistent with the fundamental feature of the legislation. This would cross the line and show the courts interfering with the sovereign rights of Parliament. So where does this lead us? As I've suggested, I think the Human Rights Act and the methods of interpretation that have followed in its wake suggest that whilst parliamentary sovereignty has not come to an end, it clearly hasn't, that the judges are reading words into an Act in order to make the Act Convention compliant. However, there is a limit to this practice. The words read in must be consistent with the fundamental principles of the Act that is in question. This, in other words, allows us to say that whilst the judges have this, if you like, subordinate lawmaking power, they cannot trespass upon the ultimate lawmaking power of Parliament. We've come a long way, in other words, from the idea of the literal rule and those earlier myths that grew up around the constitutional position of the judiciary. What I think indicates these broader issues, these broader concerns in the contemporary constitution and these contemporary judicial practices, is the following statement from Jack Straw, former Minister of the New Labour government, who in a parliamentary debate argued that, quote, "Parliament and the judiciary must engage in a serious dialogue about the operation and development of the rights in the bill." That was when the Human Rights Act was still a bill. "This dialogue is the only way in which we can ensure that legislation is a living development that assists our citizens." We could then perhaps speak of a dialogue over rights, over human rights, developing between the courts and Parliament. And if we follow Jack Straw here, this dialogue is the only way in which we can ensure that legislation itself is a living development that assists our citizens. In other words, from Jack Straw's perspective, or at least Jack Straw's perspective in 2000, and it's cited in 2003, I think he's saying this in a somewhat earlier period, if we can follow the argument that what is necessary is enhanced human rights protection for citizens within the United Kingdom.